On an unspecified date, Deputy Trevor Lewis of the Sumter County Sheriff's Office initiated a traffic stop on Interstate 75 southbound in Florida for a window tinting violation. What began as a routine equipment citation evolved into a significant narcotics investigation after a certified police K-9 alerted to the presence of controlled substances. The interaction that followed demonstrates the escalation from minor traffic infraction to suspected felony trafficking, raising questions about search and seizure procedures, detention protocols, and the use of drug detection dogs during traffic stops. This analysis examines the legal and tactical aspects of this investigation, which allegedly resulted in the discovery of approximately 9 kilograms of narcotics concealed within the vehicle's structural compartments.
You have a license with you today? Okay. Is this your car? Okay. Any issues with your driver's license today? Well, yeah, other than being lost, suspended or anything else like that? Okay. Okay, well, I'll tell you what, let's do this. I'm going to give you a paper and a pen. Can you write down your information for me? Name, date, birth, social security number. What took you all the way out to Texas? Oh, really? Whereabouts in Texas?
Deputy Lewis initiates contact with the vehicle's driver, Elizabeth Espinoza. The deputy immediately requests identification and inquires about her driver's license. Ms. Espinoza indicates she does not have her physical license, with her stating she has only a photograph of it. Under Florida statute section 322.15, drivers must possess their physical license while operating a motor vehicle. However, this violation is classified as a non-criminal traffic infraction, and charges are typically dismissed upon proof of valid licensure at the time of the stop.
You had your registration as well, ma'am. Are you still with Infinity?
Yes, I just registered with them 2 months ago.
Yes, the reason why I'm stopping you is your side window tint, which I'll check here in just a minute. Is that something that you had done or something you bought the vehicle with?
Deputy Lewis explains the reason for the traffic stop: excessively dark window tinting. He provides a detailed explanation of owner responsibility for vehicle equipment violations, using analogies to defective lights and tires. This educational approach demonstrates professional communication. In Rin versus United States, decided in 1996, the Supreme Court established that any traffic violation, regardless of how minor, provides constitutional justification for a vehicle stop. This means that even if an officer has ulterior investigative motives, the stop remains valid as long as an objective traffic violation exists.
I don't know if you can see that or not, probably not, but your back window is coming in at 2% light transmittance. As dark as you can have it on any of the windows behind the driver's seat is 15. Well, we'll check this one in just a minute. So any number less than 15,
using a tin measurement device, Deputy Lewis documents that the rear window measures 2% light transmittance, while the front passenger window measures 13%. Under Florida statute section 316.2953, front side windows must allow at least 28% light transmission. The front passenger window in this case is 15% below the legal threshold, providing clear, reasonable suspicion for the traffic stop. Florida law allows rear windows to be tinted to any darkness if the vehicle has dual side mirrors, but the front window violation alone justifies the stop.
All right, well, I'll tell you what, Miss Espinoza, I'll give you a chance to stretch your legs here. Would you just grab your key and step back here? I'm going to check your information. Yeah, just bring a key with you. That's fine. Yeah, switch it off, and that way you're not wasting gas. Gas is too expensive to, I just have you step over here on the grass.
Deputy Lewis requests that Ms. Espinoza exit the vehicle and wait at the rear while he checks her information. The Supreme Court in Pennsylvania v. Mims, decided in 1977, held that officers conducting lawful traffic stops may order vehicle occupants to exit for officer safety reasons. The court recognized that traffic stops are inherently dangerous, and requiring occupants to exit is a minimal intrusion justified by substantial safety concerns. Deputy Lewis positions Ms. Espinoza on the grass shoulder away from the roadway, demonstrating attention to both officer safety and civilian safety from passing traffic.
1188 at 97.
While Deputy Lewis processes Ms. Espinoza's information, a K-9 handler arrives on scene. This timing becomes legally significant. In Rodriguez versus United States, decided in 2015, the Supreme Court held that police cannot extend a traffic stop beyond the time reasonably necessary to complete the stop's mission unless they have independent reasonable suspicion of additional criminal activity. The question in cases like this becomes whether the K-9 deployment extended the stop or whether it occurred within the time naturally required to complete the traffic stop paperwork and investigation. Deputy Lewis returns to inform Ms. Espinoza of the stop's resolution. He indicates he will issue a warning for the window tint violation and a citation for failure to possess a driver's license. He explains that if she presents proof of a valid license to the clerk's office within 30 days, the citation will be dismissed for a $10 administrative fee. This represents a routine traffic stop resolution. At this point, the interaction appears to be concluding, and Ms. Espinoza would normally be free to leave once the citation is issued. However, what happens next transforms this routine stop into a significant criminal investigation.
Just get yourself a new copy of your driver's license. Take that copy of your driver's license up to the clerk's office here in Bushnell and present them with the new copy of your license, and that ticket will be dismissed. Okay, it'll just be we're in Bushnell and something. Okay, I'm going to give you all the information that you'll need here. Okay. Hey, Ms. Espinoza, any reason
the interaction takes a significant turn. Deputy Lewis asks whether there is any reason the search of the vehicle will reveal contraband. This question, while phrased conversationally, serves an investigative purpose. Ms. Espinoza denies any such reason. The deputy then asks about medical marijuana registry status and hemp products. These questions suggest that a canine has been deployed and may have detected an odor. Under Florida law, medical marijuana patients possess cannabis legally, and hemp products containing less than 0.3% THC are also legal. By eliminating these legal explanations, the deputy establishes that any canine alert cannot be attributed to legal substances.
Check it just to make sure there's nothing in there that shouldn't be. Okay. You're not under arrest, but you are going to be detained. Detained means that you're not free to go right now. Okay?
Deputy Lewis informs Ms. Espinoza that a trained police canine has alerted to her vehicle indicating the presence of narcotics. This statement is legally significant. In Illinois versus Caballos, the Supreme Court held that a canine sniff during a lawful traffic stop does not constitute a search under the Fourth Amendment, as individuals have no legitimate privacy interest in contraband. In Florida versus Harris, decided in 2013, the court established that an alert by a certified drug detection dog provides probable cause to search a vehicle. Deputy Lewis clearly explains Ms. Espinoza's status. She is detained, but not under arrest. This distinction is important under Terry versus Ohio. Detention is a temporary restriction of freedom of movement based on reasonable suspicion, while arrest requires probable cause.
Just have a seat for me, please.
Before placing Ms. Espinoza in the patrol vehicle, Deputy Lewis asks about weapons and conducts a pat-down search for officers. Under Terry versus Ohio, when officers have reasonable suspicion that an individual may be armed and dangerous, they may conduct a limited pat-down search of outer clothing for weapons. While the deputy is not required to have specific articulable facts that Ms. Espinoza is armed, the combination of the narcotics alert and the impending vehicle search provides reasonable justification for a weapons check. Deputy Lewis clearly announces his actions, for the body camera uses the back of his hand during the search and maintains professional boundaries throughout. Ms. Espinoza complies with all instructions and does not resist detention.
Me acaban de agarrar, estoy en Bush now, and I need to go pick up my kids. Estoy detenida. Yeah. No, tienen en perra. I don't know. Me dijeron que because of the tents, they said the tents were too dark, and there's another one here, and the K9 olió algo, so I don't know. Okay. Bye-bye.
After a considerable wait while officers search the vehicle, Deputy Lewis returns to update Mrs. Espinoza. He indicates that items have been discovered that require closer examination, and the vehicle needs to be placed on a lift for thorough inspection. This language suggests that narcotics have been found concealed in compartments, not easily visible to the roadside surface. When drugs are hidden in restricted areas such as behind panels, inside frame, or within the headliner, law enforcement typically requires specialized equipment to safely extract the evidence without damaging the vehicle or destroying the evidence itself.
Back there, Ms. Espinoza?
Yes, I'm fine.
Hey, this is what's going on. There are some items in the vehicle that we need to take a little bit closer look at.
Okay.
And we need to inspect the vehicle
Deputy
a little
Lewis
bit further.
explains that the vehicle will be towed to a nearby facility for detailed examination. The conversation then shifts to the deputies discussing what has been discovered. Officers can be heard estimating approximately 9 kilograms of narcotics. To provide context,
business
9 kilograms
just
equals
right up here
approximately
at the next
19.8 pounds.
exit
Under
just
Florida
north of us.
statute, Section
Okay.
893.135, trafficking in
just gonna
controlled
hang tight with
substances
me
is
and
established by
we're
weight
gonna
thresholds
follow
that
your
vary
lead.
by drug type.
Okay.
For most narcotics, 9 kilograms far
It's been
exceeds
about
trafficking
4 months
thresholds and
since
will carry
you-
mandatory minimum prison
If,
sentences
you do the
ranging
math
from
on it,
15 to 25 years,
If
depending
that's
on the
all, let's
specific
just say it's
substance
9
identified.
kilos.
You do it by the
2.2
gram, correct?
What's that?
You do it by the gram, correct?
Yeah, but I'm just saying if it's 2.2 pounds a kilo,
Yeah.
if that's how it works. 20 pounds.
Officers discuss the concealment method referencing the removed headliner and
Yeah, it's
tools,
true. I didn't
suggesting
look at that.
professional
That's going to be
The presence of tools and
largest,
modified
hot,
compartments may be
cold,
relevant
you
to
name it,
establishing
and as
knowledge
cold
and
as cold
intent
as cold.
in any
You know what I'm
prosecution.
saying?
Deputy
So,
Lewis then asks about Miss
this
Espinoza's
could be
criminal
that. I think there's more
history. She
in there
reports a
somewhere.
single
Yeah, now
arrest
with that
for
headliner
aggravated assault
and,
in
pulled
2013
out
for charges of
that
substance
cork
drugs.
of it.
While prior
Also,
criminal history is generally not admissible to prove guilt in a new case, it may be considered during sentencing
Miss
if
Espinoza,
conviction
have you ever
occurs.
been arrested?
The question serves an
I
investigative
got arrested
purpose,
back in
helping officers
2013.
assess the overall
In
situation.
2013?
Yes.
What was that for?
Aggravated assault.
Anything between then and now?
No. No.
What was the disposition of that case, ma'am? In other words, what happened with it?
Oh, charges got dropped.
Deputy Lewis continues gathering background information, establishing Ms.
Within a month.
Espinoza's current address. This information serves multiple
domestic
purposes.
situation?
It will be included in any charging documents may be relevant to establishing
Yeah, I
residency for
believe
jurisdictional
so, whatever that
purposes.
means. I
It
don't
could
know
be
what
used
that
for
means.
search warrant
Okay, was it
applications
with a
if
person in your
investigators seek to
household?
search
Yeah,
her
it was
residence.
with my
Person you
kid's
were
dad.
Deputy's
Yes.
thorough documentation
Person you were in
demonstrates
a relationship
proper
with. Yes.
investigative procedure. However, Ms. Espinoza is not
Is that
required
an
to answer these
apartment or-
questions.
Yes, it's an
While she
apartment.
must provide her driver's
Is there
license
an
registration
apartment number
and proof of
associated
insurance
with
during a
that?
traffic stop, she
Or
has
is it
no
just
obligation to
the,
answer questions about her
918?
residence or
Well,
personal
I
life,
don't. There is an
particularly once the
apartment
stop
number,
has
but I
evolved
don't
into
know
a
it,
criminal
to be
investigation.
honest.
I think there was an envelope in the passenger side door. It said 1107 or something like that.
Yeah,
Does that sound right
yeah,
to you?
probably yes.
Okay.
Or
Well-
1007.
Okay.
Yeah.
Whatever that
The
number
deputy
was,
asks
there's a
about
number
Ms.
written on
Espinoza's
that.
employment
So
and
that would be your
These
apartment
questions
Yes,
may
number.
seem
correct.
like casual conversation, but serve investigative purposes. Employment information helps establish whether the subject has legitimate income sources, whether she
Working at
travels for
Amazon
work,
now, you
and whether her
said?
stated
Yes.
activities are consistent
Which
with her
location?
lifestyle. Officers may later investigate whether she actually works at the claimed location
We're about
and whether
to
her
arrest
employment
her. Is it a
records show
distribution
suspicious
center?
activity,
Yeah, it's a
such as
district-
excessive
yeah.
absences or recent
Whereabouts
termination.
is that
Ms.
located?
Espinoza mentions previously
I have
living in
no
Wisconsin,
clue, to
which
be
may be
honest.
relevant if investigators suspect
When
interstate
you
drug
go to work,
trafficking.
what?
Again, she's not required to answer these questions, but she continues to
It's on
cooperate.
674, but I don't know the exact road because I've lived in Western for so long. Sorry. Yeah.
I'm not as familiar with that area. I know about the distribution center that's over there in Lakeland.
Despite the ongoing drug
Yeah,
investigation,
yeah, I know
Deputy
they have
Lewis
it out
follows
there,
through
yeah.
with issuing the traffic citations that provide a basis for the stop. This demonstrates
I
proper
just
procedure.
pack.
The window tint violation and failure to possess a license remain valid infractions regardless of the subsequent drug discovery. By providing clear instructions for resolving the traffic citations,
these
the
are
deputy
yours?
maintains the legitimacy of the original
Okay.
stop.
Warning notice
However,
for
these
the
traffic
window
infractions
tint
will
and
likely
a
become
ticket for the-
insignificant compared
Okay.
to any
Not
traffic
having
charges
your
that may
license
follow.
with you?
The professional handling of the
Like I
routine
said,
traffic
as long
matters
as you take
while
your
simultaneously
license to the
conducting a
clerk's
major
office
drug
within 30
investigation
days.
demonstrates
Okay.
the deputy's
It'll
ability
just be a
to manage
$10
multiple
service
aspects
fee
of
to the
law
clerk's
enforcement
office.
duties.
And that'll be it. If you don't do that within 30 days, the fine amount is $116. There's no points either way.
Oh, okay.
A significant period passes while officers conduct a detailed search of the vehicle. Ms. Espinoza remains detained in the patrol car during this time. Under Fourth Amendment law, the length of detention must be reasonable given the circumstances. In this case, where a K-9 has provided probable cause and officers are conducting a search of a vehicle with concealed compartments, an extended detention is legally justified. The search cannot be unreasonably prolonged, but the complexity of searching structural compartments containing substantial quantities of narcotics makes a lengthy search reasonable. Ms. Espinoza's frustration is audible, which is understandable given the circumstances, but her continued compliance prevents escalation of the situation. The investigation has now moved to the sheriff's office. Ms. Espinoza has been detained for several hours at this point. Deputy Lewis demonstrates appropriate attention to her basic needs, providing water,
Miss
adjusting
Espinoza,
temperature,
you doing
and arranging
okay?
for restroom
Yeah,
access.
could I get
Courts
a
have held
water or
that
something?
during
Water?
extended
Yes.
detentions,
How's the
officers must
temperature?
provide
Is it
reasonable
okay?
access
Is it
to
still
basic
warm?
necessities.
It's a
Failure
little
to
too
do so
warm.
can
Is
support
there a
claims of
bathroom I can use?
unconstitutional conditions of
Yes,
detention.
bear with
The
me.
deputy's
Okay.
attention to these details demonstrates professional standards and reduces liability risk. Providing these accommodations also serves an investigative purpose. Subjects who are treated with basic
Water?
dignity are more likely to
And I'll see
cooperate
about a
during interviews.
bathroom.
Okay. Christ. Jesus. Fucking Christ. Bullshit.
In the background, an officer's reaction to the search results can be heard. The significant quantity of narcotics discovered clearly impacts even experienced law enforcement officers. Deputy Lewis returns to inform Ms. Espinoza that a female deputy is en route. The requirement for a same-gender officer for certain searches and escorts reflects department policy designed to protect both subjects and officers from allegations of impropriety. This professional standard is particularly important
Miss
when dealing with
Espinoza,
detained
female deputy
individuals
should be
who
here
may
any
later
minute.
make
Let's
arrests.
use the restroom,
The brief
okay?
delay while awaiting the female deputy is reasonable and demonstrates attention to proper procedure even during a major investigation.
All right, she should be here in a minute.
Okay.
Tell you what, Miss Espinoza, I'm not gonna cite you for not having your license. Just make sure you
In an
give me a
interesting
copy of it,
development,
okay?
Deputy Lewis indicates he will not proceed with the citation
That way you
for
don't have a
failure
ticket
to
to
possess
worry
a driver's
about.
license. This
Are you
discretionary
guys
decision may
almost
serve
done,
several
or
purposes.
can you
It
let me know
demonstrates
what's
a degree
going
of
on?
professional
Yes, I
courtesy
think
or
we're almost
recognition
done.
that the traffic
Right
violation
back.
is insignificant
Okay.
compared to the
Actually,
potential trafficking charges.
yeah,
It may
right
also be
here.
intended to maintain rapport before requesting an interview. Officers sometimes use such gestures to encourage cooperation during
Yes, sir.
investigations. Ms. Espinoza asked about
Appreciate
the
your
investigation
cooperation
status,
so far this
showing
afternoon. I
understandable
know it's been a
anxiety
long
about the prolonged detention.
day.
The
Has
deputy's
been for
response
us
that
too.
they are almost finished suggests
I'd
the
really
search
like to
has
talk to you
concluded,
about
and
what
the
happened this
investigation is
afternoon.
moving toward a resolution phase.
Is that something you'd be willing to do? Talk about what happened, the traffic stop and everything?
Mm-hmm.
Okay. Well, once
Deputy
the
Lewis
female
makes a
deputy
formal request to interview Ms. Espinoza about the
gets here,
investigation. His
lets you
approach
use the
demonstrates proper
restroom and
Miranda protocol.
get all
He acknowledges
comfortable.
the seriousness
There's
of the
a
situation
room
without
inside
making specific
that
accusations,
we can
requests,
kind of
voluntary
be away
cooperation,
from
and
everybody
explicitly states
and
that he will advise her of her
just
rights
like
before
to
the
interview you.
Under Miranda versus
See
Arizona,
what you might be
custodial
willing to
interrogation
tell me
requires
about
rights
what happened
advisement.
today,
Ms.
okay?
Espinoza is clearly in custody at this point. A reasonable
What I'll
person would not
do
feel free to leave.
is,
The deputy's statement that he will provide
like I
Miranda
said,
warnings
once we get
before
in there,
questioning
I'll
shows
just
proper
advise you of your
constitutional
rights
procedure.
once we get in
Ms.
there,
Espinoza's
and then we
response
can
suggests she
go
may
from
be
there.
willing to talk,
Okay?
though she has not yet been formally advised of her right to remain silent and her right to an attorney. At
I
this
think
critical
you already
juncture, the video
understand
concludes
what-
before the formal interview begins.
What's going on is pretty serious, though. All right. There's female deputy.
Around this.
She'll be able to escort you into the restroom.
Okay. Put your hand up there. Ready to be. There's nothing on you. Just gonna poke me.
The outcome of this case remains unknown at the time of this analysis. Attempts to locate charging documents, court records, or news coverage were unsuccessful. However, based on the quantity allegedly discovered, approximately 9 kilograms of narcotics, if charges were filed, they would almost certainly constitute trafficking under Florida law. Florida statute, section 893.135, establishes weight-based trafficking thresholds. For cocaine, trafficking begins at 28 grams, for heroin 10 grams, for methamphetamine 14 grams. 9 kilograms of any of these substances would place this case in the highest trafficking tier, carrying mandatory minimum sentences of 15 to 25 years in Florida state prison. If federal prosecutors elected to charge under federal drug trafficking statutes, penalties could be even more severe. The professional concealment method, described by officers as hidden compartments in the vehicle's structural areas with tools present, will support trafficking charges rather than simple possession as such concealment. Suggests intent to transport for distribution rather than personal use. Deputy Trevor Lewis of the Sumter County Sheriff's Office receives an A- because he demonstrated professional law enforcement standards throughout this investigation, while managing a complex escalation from traffic stop to major narcotics case. The deputy's constitutional compliance was strong. The initial traffic stop was clearly supported by an observable violation, excessively dark window tinting. His measurements documented front window tinting at 13%, 15%, below Florida's minimum 28% standard. Under Wren versus United States, this objective violation provided firm constitutional footing for the stop regardless of any investigative motivations. The deputy's use of the certified canine appears to have occurred within the time reasonably necessary to complete the traffic stop, though the video does not show the precise timing of the canine sniff in relation to when the routine traffic stop would have concluded. This timing can be critical under Rodriguez versus United States. The deputy clearly communicated the distinction between detention and arrest, explaining that Ms. Espinoza was not free to leave but was not under arrest. This demonstrates understanding of Fourth Amendment detention standards. His announcement that he would provide Miranda warnings before the interview shows proper Fifth Amendment procedure. Deputy Lewis also demonstrated strong tactical awareness and officer safety practices. He positioned Ms. Espinoza away from traffic during the roadside portion of the stop. He conducted an appropriate pat-down search before detention based on reasonable safety concerns given the narcotics investigation. He maintained professional demeanor throughout, avoiding confrontational language even during stressful moments. His attention to Ms. Espinoza's basic needs during extended detention, providing water, addressing temperature concerns, and arranging for restroom access, reflects both constitutional requirements and professional courtesy. His decision to forego the driver's license citation while discretionary showed flexibility and may have encouraged cooperation. However, several areas warrant consideration. The video does not clearly establish whether the K9 deployment impermissibly extended the traffic stop. If the K9 sniff occurred after all tasks related to the traffic violation were completed, and if the deputy lacked independent, reasonable suspicion to justify extending the stop, this could present a Fourth Amendment issue under Rodriguez. Courts carefully scrutinized the sequence of events during traffic stops involving K9S to ensure the stop was not prolonged solely for drug interdiction purposes. Additionally, while the deputy was professional, he engaged in extensive questioning about Ms. Espinoza's background, employment, and travel after the K9 alert, but before providing Miranda warnings. While she was not yet in formal custody during the roadside portion, and thus Miranda may not have been required at that stage, her responses to these questions could potentially be challenged if she was not free to leave at the time. Overall, Deputy Lewis handled a significant drug interdiction, professionally maintained constitutional standards, demonstrated tactical competence, and managed a prolonged detention without incident. The minor deduction from a perfect grade reflects the Rodriguez timing ambiguity present in the video and the extensive pre-Miranda questioning both areas that could face scrutiny during legal proceedings. Elizabeth Espinoza receives a C+ because while she maintained composure and complied with lawful orders throughout the detention, she made several critical legal errors that significantly damaged her legal position. Most significantly, Ms. Espinoza answered extensive questions without asserting her Fifth Amendment right to remain silent or requesting an attorney. After Deputy Lewis informed her that a K9 had alerted to her vehicle and that she was detained, the situation had clearly evolved into a criminal investigation. At that point, she had no legal obligation to answer questions about her travel, employment, residence, or background. Every answer she provided gave investigators additional information that could be used against her in court. Her statement that she had been in Texas visiting a friend but could not identify the friend's location, combined with her admission that she previously lived in Wisconsin, could support prosecution theories about interstate drug trafficking. Her employment at Amazon could be investigated for inconsistencies or used to establish whether she had legitimate income sources. Under the Fifth Amendment, she had an absolute right to state, "I am invoking my right to remain silent and I want to speak with an attorney." Had she made this statement, all questioning would have been required to cease immediately. The fact that she had not yet been provided Miranda warnings at the roadside does not eliminate this right. The Fifth Amendment applies at all times, not only during custodial interrogation. Officers are required to provide Miranda warnings only before custodial interrogation, but individuals can invoke these rights at any time. Additionally, Ms. Espinoza indicated willingness to be interviewed at the sheriff's office, while Deputy Lewis promptly stated he would provide Miranda warnings before that interview. Agreeing to speak with law enforcement about a serious felony investigation without an attorney present is legally perilous. If substantial quantities of narcotics were found hidden in her vehicle, anything she says to investigators, even if she denies knowledge, can be used to establish consciousness of guilt, inconsistent statements, or other prosecution theories. The correct response would have been, "I am invoking my right to remain silent, and I want an attorney present before any questioning." Even innocent individuals should invoke these rights during serious criminal investigations, because the legal complexity exceeds non-lawyer understanding. However, Ms. Espinoza deserves credit for several aspects of her conduct. She remained calm throughout a stressful and prolonged detention, lasting several hours. She did not physically resist at any point, complying with instructions to exit the vehicle, submit to a pat-down search, and remain in the patrol car during the investigation. Physical resistance would have added additional charges such as resisting arrest or battery on a law enforcement officer and could have resulted in use of force. She did not make any spontaneous incriminating statements or admissions. While she answered questions, she did not volunteer information beyond what was asked. She maintained relative composure even when making phone calls. While detained, though, her distress was evident. Her compliance prevented an already serious situation from escalating further. The fundamental issue is not Ms. Espinoza's demeanor or cooperation, which were appropriate, but rather her failure to exercise critical constitutional protections. When facing potential trafficking charges carrying 15 to 25 years, mandatory minimum prison time, asserting the right to remain silent, and requesting an attorney are not optional, they are essential. No amount of politeness or cooperation will overcome the legal consequences of a trafficking conviction if the evidence supports such charges. The grade reflects this critical legal error despite her otherwise appropriate conduct. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.